was expanding. Let us quickly have a look at how the concept of human rights came into being as a part of an international law, and how this human rights concept was turned into an actionable procedure in the United Nations, so that people can not only imagine that they have human rights, but also can use the system, the United Nations system, to ensure that some of these human rights are implemented on the ground. But even before we go into the very technical details, I think it is important for us to understand the historical, political factor that made human rights a very important issue at the in history. We can go deep into history, of course, to the Magna Carta and the French Revolution, and even beyond that, how many cultures and traditions respect some form of human dignity and honored it. And that's the reason why we survived as a species. But to come very concretely on where the modern human rights came about, we have to go back at least to the Second World War. As we all remember, Second World War was fought between the Axis, where the German, the Italy, and Japan was in one group, and the Allied, where the British, French, and later America was fighting on the other side. As we all know, and in the first phase of the Second World War, the Germans were capturing almost the whole of Europe. There was a moment where Britain was the only country which was left to be taken over. And at that time, Winston Churchill was the Prime Minister of the Great Britain, and he was persuading America to come on board to fight the war together with them as allied, because America was emerging as a very important power at that point of time. Its resources was huge, and without America, Britain was feeling the threat, because the whole of continental Europe was already in the hands of the Nazi Germany. At that time, in fact, in August 1941, after a lot of persuasion, the Pearl Harbor incident happened. And finally, at that time, the President of America was President Roosevelt. So President Roosevelt finally agreed to have a meeting with Winston Churchill. So two of them, in August 1941, two of them came in a ship, one from Britain, one from America, and they met somewhere in Atlantic and near an island. And on a Sunday morning, they came to the deck of the one of the ship, and they agreed on 10 points of agreement of how America will join the Second World War. And this is what we call historically the Atlantic Charter, because it was done on the Atlantic Ocean, and it was a Sunday morning. We were told Winston Churchill was too busy with the war, so he just put main points, and 10 points was agreed upon. And this was in fact a very interesting declaration, which basically claims that if this war is won by the Allied, they will make this colonialism a history. It will be a war of liberation. Whereas the Nazi Germany was going and occupying all the country, what Atlantic Charter said was, among many other things, the most important point was that when the Allied take over territory, it will not be under the Allied power. They will be given the self-determination, that each country will become free and live their own life, decide their own future. So it is actually a war to fight for freedom of people, not just a war between two great powers. The other point that was there, which is very important for human rights, was not only would the nations be made free, but also that what they are trying to do is to ensure that every human being is free from want and free from fear. Freedom from want is that you will have your basic economic, social, and cultural rights. I mean, freedom from want concept emerged into eventually the human rights of economic, social, and cultural rights. And this freedom from fear is what finally came out as the what you call civil and political rights, that everyone should live in freedom, everyone should have a right to participate in the governments, every human being will be respected of their civic rights by whoever government that comes to rule over them, be they freedom of expression, freedom of association and assembly, freedom of movement, etc., etc. So this was a big promise that Atlantic Charter have given. I mean, let us know. I mean, I do not have the time to go to the great details of it, but what was very interesting was this was a promise in the middle of the war, and this was the condition on which America became a part of the Allied, and eventually, fortunately or unfortunately, the Allied won the war, and they settled down after the war. When the war was almost over in 1945, they set in the city of Chicago, and they set out drafting the Charter of the United Nations. And in the Charter of the United Nations, this principle of human rights became a very fundamental element. If you look at the preamble of the Charter of the United Nations, it reads, "We, the people of the United Nations, determined to save successive generations from the scourges of war, which twice in our lifetime have brought untold sorrow to mankind, to reaffirm faith in the fundamental human rights, in the dignity and worth of human person, in the equal rights of men and women, of nations large and small." So in the preambular paragraph number 2 itself, the word to reaffirm the faith in fundamental human rights, in the dignity and worth of human person, in equal rights of men and women, of nations large and small, was enshrined very deeply. I mean, first one was, of course, to prevent war. This is the second point in the second top priority, so to speak, besides saving the world from the scourges of war. Then, of course, the third one was to establish conditions under which justice and respect for the obligation arising from the treaties and other sources of international law can be maintained, etc., etc. It goes on. So what is interesting is, because of this struggle and because in the middle of the war, there was this need for making a big promise to the world, and this promise was followed through in the Charter of the United Nations. Human rights have become a very fundamental element, or one of the key objective for which this the United Nations was formed. But there are also interesting history. In fact, you know, when Winston Churchill and all have made these big promises in the middle of the war, but when the war was settling down, some countries sat in Washington and try to kind of imagine the next, basically agreed on basic formulation of the United Nations. But there was an effort to get rid of human rights and get into more real politics. But there was a groundswell of movement, people demanding from various quarters that this Dubon Oak Declaration, they call it, was not strong in human rights, and human right needs to be brought in. There is a fundamental problem in inserting human rights that most of the government have been reluctant to, because if you say international law recognizes that every human being have human rights, and somehow this has to be implemented by not only by the government themselves, but also by the international body like the United Nations. Then many government feels that their sovereign immunity principle, which was what has been governing international law and for time immemorial, so to speak, is being questioned. So many people are hesitant, even though theoretically they all talk about human rights, to practically bring in human rights. It becomes that some amount of your sovereign immunity, that I am the government, I am the sovereign of this country, and I can do anything that I want, would be limited by this concept of human rights. And in fact, in the very first General Assembly of the United Nations, which was held in 1946, it was interesting that it was Bijaya Lakshmi Pandit from India who took the floor and started criticizing South Africa for this apartheid regime and this racist laws that they are implementing. And this provoked the ambassador of South Africa at that time, his name was Mr. Jan Smuth. He stood up and he retorted against Bijaya Lakshmi Pandit and said that he quoted Article number 2.7 of the Charter and said, the treatment of Indians, colored and mixed race was purely and simply a matter of domestic jurisdiction. And he ominously warned, if UN is allowed to intervene in South Africa, it will set a dangerous precedent and it will destroy national sovereignty. To this, Bijaya Lakshmi Pandit rose up again and dismissed the legal argument about domestic jurisdiction. And I quote her. She said, "It is a bit late in the day and far-fetched and make a mockery of the principle of enunciated in the Charter." And she basically said that this whole legal argument of domestic jurisdiction is no longer applicable when it comes to human rights debate. And so the first, even though, I mean, this entered into very hot exchange between South Africa and India, and then finally the General Assembly have asked that this matter should be resolved amicably, separately, and not in the floor of the General Assembly. But what was interesting was this first strike by Bijaya Lakshmi Pandit have woken up the rest of the world that we are now in a new era where sovereign impunity cannot be the sill to stop the United Nations or the international body to start talking about human rights in your own domestic context. So this was quite a historic moment, and this continued for a long time. In that very General Assembly on the 1946, the General Assembly also took a resolution to constitute a committee. I mean, it has asked the Economic and Social Council, or ECOSOC, to draft the International Bill of Rights. I mean, the Charter, which was written in 1945, have made human rights as a fundamental principle that around which the country should govern themselves. But what exactly would be the content of this human rights was not very clear to any one of them. So in 1946 itself, they made a resolution and asked ECOSOC, the Economic and Social Council, which is one of the specialized organs, to work out a draft of what the International Bill of Human Rights would look like. So at that time, fortunately or unfortunately, President Roosevelt have already died just before the United Nations came into being. And so President Truman was the president of America when all these things was happening. And as an honor to President Roosevelt, remember, he was the one who put the seat in the Atlantic Charter. As a mark of respect, the American establishment made Mrs. Roosevelt as the chair of this drafting committee to work out the draft of uh, uh, the first International Bill of Rights. Eleanor Roosevelt was the chair of this committee, and when they try to sit and decide what could be the content of this human rights, I mean, a right where every human being, whether they're irrespective of whether they are rich or poor, black or white, or coming from developed countries or underdeveloped countries, to have that kind of a document was by no means easy. And so initially, when they try to work out, they realize that there are huge differences in terms of philosophical underpinning of the understanding of what human rights should be all about. So they took the help of UNESCO, because UNESCO is the one which does most of the intellectual, philosophical, cultural work in the United Nations. And they form a committee on philosophical principles of rights of man. And they wanted to actually do a big conference, but unfortunately, because of all the logistical problems in 1940, we're talking about 46, 47, it was impossible to do that. And because the world was just coming out of the Second World War, everybody was quite busy trying to reconstruct their own this thing. Instead of doing a conference, they started sending out questionnaires to all the people, different parts of the people, people who are opinion leaders in different parts of the world. And we were told that in the archives of the United Nations, they sent this questionnaire to Mahatma Gandhi in India, as well as to Jawaharlal Nehru. Unfortunately, Jawaharlal Nehru probably was too busy at that time with the independence and the partition. He didn't quite find time. But interestingly, Mahatma Gandhi did reply to this questionnaire, where he said something like, a true human rights should come out of because of the fruit of performing our duty effectively. Anyway, but without, they collected all these questionnaires from all over the world. And finally, after a lot of debate, and interestingly, in the committee that was set up to draft the Universal Declaration on Human Rights, there was one representative from India, and she was Hansa Mehta. She was a diplomat, she was a congresswoman, she was involved in the national struggle, and she was raising a lot of critical questions in the process of drafting committee. And after a lot of drafting, two big contribution, if I may just mention, of Hansat Mehta was, earlier they were calling it the right of men, or all men are born free and equal, was the beginning phrase of the Universal Declaration on Human Rights. Because this was basically cut and paste from the American Declaration on Rights of Men, and as well as the French Declaration on Rights of Men. There, the word that was used was, all men are born free and equal in dignity and rights. Hansat Mehta challenged this and said, you cannot say men anymore, but you need to convert it as humans, because it includes both men and women. But Eleanor Roosevelt tried to convince her that, when we are saying men here, it basically is used in a generic term. So when we say men, it means both men and women. But Hansat Mehta insisted that if it means exactly that, then why don't you replace the word men by human? So because of that, the word that we see today in the first line of Universal Declaration on Human Rights was, all human are born free and equal in dignity and rights. So that was a huge contribution of the Indian representative in that debate. And also there was a reference to God. When you try to bring the philosophical underpinning of where this human rights was emerging from, there was a reference to God in the initial draft, but Hansat Mehta insisted that God could be very problematic, because there are some people who do not quite believe that it exists. And even if it exists, there are, again, different manifestations. So instead of using the word God, she proposed that the word nature should be used. So now in its present form, the Universal Declaration on Human Rights uses the word nature rather than God. Anyway, the debate was quite alive and challenging, so to speak, because many people from different philosophical background, the Marxist communist bloc that were arguing in those terms. There were also Shariat law, propagators of Shariat law from Muslim country, which was trying to insert more of the Quranic principles. There were Confucians from China, which was trying to bring in the Confucius ideas. But all said and done, after a long debate, the draft declaration of the Universal Declaration of Human Rights was finally passed on the 10th of December, 1948, in the General Assembly, which was held in Paris at Palais Chillot, as it was called, and that day Russia was not quite happy. I mean, at that time USSR was still not very happy, and they insisted that the draft needs to be discussed one more year and it should be adopted in the next year. And out of 48 governments which was present, they have voted in favor, and there was no opposition, but 8 countries abstained from voting, including USSR and also many of the Arab countries. They were not happy with the formulation of the rights of women, which was equality of women that was placed. So on the 10th of December 1948, this Universal Declaration of Human Rights, containing 30 articles, was adopted by the United Nations General Assembly. And this has become the most historic document in many sense, because human beings have been living in this planet for I don't know how many millions of years, but this was the first time in history where the world body recognized that every human being, irrespective of caste, creed, or just nationality or level of development, are all given a right which is supposed to be protected both by the governments, respective governments, but also by the international community and the United Nations. And for the first time, a consensus document with, again, some abstention, but no objection, a document was put into place. And this created such a hope, and aspirations of the people rise like anything. But let me caution that this was only a declaration that was made. And in the drafting committee, they decided that there should be first a declaration that we draft. And then after that, a declaration is only an expression of will. They wanted to come out also with what they call a covenant. Covenant meaning that it should be something that is legally binding. And it was not, right after the Second World War, there was a lot of consensus in the world to how to, formulate the human rights principles. But as time goes by, the world started getting divided into the Cold War on ideological grounds. One was led by the United States, which are more what they call themselves, what to call democracies or capitalist, and the newly emerging power led by the Soviet bloc, the USSR, which is basically more socialistic and sometimes communist. And the debate of human rights also started getting polarized on ideological lines. The American bloc insisting that civil and political rights are the real rights. And similarly, with equal vigor, the USSR's socialist bloc was insisting that this is civil and political rights is basically a right for the rich people. Here, what we need in developing countries is roti kapra or makan, or the economic, social, and cultural rights. There's no meaning of freedom if people are hungry. If people are poor, it makes no sense. So because of this divide, it took a much longer time for the covenant to be developed. But finally, the covenant came in not one, but in 2 forms. One is called the International Covenant on Economic, Social, and Cultural Rights. The other one is called the International Covenant on Civil and Political Rights. So the people who are interested and in civil and political rights, that grouping of country took the leadership of drafting the the civil and political rights. The one which is interested in economic, social, and cultural rights took the initiative of drafting the economic, social, and cultural rights. So in 1966, we have this two covenants, the International Covenants on Civil and Political Rights and International Covenants on Economic, Social, and Cultural Rights. So this three document, the Universal Declaration on Human Rights and this two covenant together is what we call the International Bill of Rights today. Yeah, I want to check how much time is allocated to me. Would the moderator kindly tell me how much more time I have? Accordingly, I'll formulate how elaborately I would like to speak for the rest of my.
Your session only from 2:30 to 3:45. It was a scheduled time, but due to 10 minutes late, this session can be up to 4 p.m. sir.
So we will be leaving some time for question and answer, or should...
Definitely, sir.
Okay, sir. So how much time should I leave for the question and answer, sir?
You can leave 20 minutes.
Okay, sir. So I should be done by 2:55. Okay. Thank you very much. Sorry, 3:50. So we are already 3 now, right? Okay. I will take till 3:25 for the lecture. Thank you very much. So, as I was telling you, what was interesting was when the Universal Declaration on Human Rights was propounded, in 1940, this was in 1948, the 10th of December, that itself have created a lot of hope to the rest of the world, especially people who think that their basic human rights are being violated by their own governments or by other powerful, forces. So many people have started writing to the United Nations that their rights are being violated, and United Nations, please take action on this. Earlier, when Eleanor Roosevelt, Hansat Mehta and all, even though the United Nations do not give them a mandate to address some of this problem, they at least took the courtesy of writing back to these petitioners saying that we have received your complaint and we are looking into it. So at least there was an acknowledgement of the complaint that they have received. But as I was telling you, there's always a balancing act that has to be done, because the governments themselves, even though on principle they agree that there are certain human rights, they don't want that international bodies like the United Nations started writing to them about human rights issues within their own territory. So this is a constant tension that exists in the movement for human rights. So many governments have started objecting to this, experts from the sorry, okay, thank you. Yeah, so there was always this tension, and so after sometimes the governments have come and said these experts in the United Nations should not respond to any of this question, because it would amount to interfering into their internal affairs. So this process stopped. After in the late 40s and early 50s. From then on, the United Nations body was asked to shut off and not to respond to these complaints that comes from either individuals or from the from groups of oppressed people who would like their issues to be addressed. But interestingly, this was also being debated internally within the United Nations, that if we are not able to respond to the real life situation there in the field, in the ground, what is the meaning of our talking big things about, all these beautiful rights, which are just beautiful words? If the government themselves are not implementing this in their government, there should be a mechanism. So when we have this the International Covenant on Civil and Political Rights and International Covenant on economic, social, and cultural rights, they set up committees that that look into how these rights are being implemented. And mind you, whereas Universal Declaration on Human Rights is a universal thing that where everybody has to follow, this covenants can be either ratified by the government or not ratified by the government. If the government thinks that they are not prepared to implement this covenants in their country, then they can say we will not sign and be a party to this covenant. But once you become a party to this covenant, and once you have signed it and ratified it, again, these are two technical terms. One has to understand that in international law, just by signing, you don't become a party. It has to be ratified in your government, in your country, either through the parliament or by the cabinet or the relevant ministry for you to become a part of that treaty. So once you become a part of the human rights treaty, either civil and political rights or economic, social, or cultural rights, then it becomes mandatory for you to submit a report to an expert committee which looks into how these human rights are actually being implemented in your country through policies, through laws, through programs, through schemes. How are they being implemented is being examined by this committee. So, and this is what they call periodic reporting. Usually, they report every 5 years. I mean, let's not go into that great detail, but the point is, when the government submits its report on how they are implementing the human rights in their country, the NGOs can also submit their report, or civil society can also submit their report saying that what government is saying is not quite complete. What is actually happening in our particular context is this. And so you can send this to the committee, and the committee will examine both the government's report as well as the report that comes from NGOs or individuals or civil society groups. And they can ask questions to the government and engage in a dialogue with the government. And at the end of that dialogue, they come out with specific recommendations on where the government is lacking in terms of policy, in terms of implementation, in terms of law, and say these are areas of improvement. They come out with what is called as concluding observations and recommendations, what the committee thinks that the government needs to do. To give an example, for example, the International Covenant on Civil and Political Rights, which is being monitored by a committee called the Committee on Human Rights, because this is perhaps the most important committee. India signed this convention in 1979. If you can all recollect, 1979 is when Janata government was there. And Janata government was a government which has been led by leaders who were badly treated by Mrs. Indira Gandhi during emergency. So when they came to power in 1979, they took a decision that we should ensure that India, people like Mrs. Indira Gandhi should not be able to put India in such a situation. So they went and signed both the International Covenant on Civil and Political Rights as well as International Covenant on Economic, Social, and Cultural Rights. So India first went with its report on how India is trying to implement civil and political rights, and it was discussed in the United Nations in 1983. If you remember, from 1979 to 1983, there is a lot of changes in terms of human rights jurisprudence in India. Procedures like this public interest litigation, which has become a favorite tool for many human rights activists across India, was basically crafted during that time. The Lok Adalat, for example, where a lot of pending cases can be resolved quite expeditiously, was crafted during that time. So when India reported about the civil and political rights situation in the United Nations Human Rights Committee, they also try to make sure that they are, the country looks good in the international community. So there were already incremental steps that was taken domestically when they went for this kind of public scrutiny in the United Nations. The second time when this, the second report of India under the International Covenant on Civil and Political Rights happened in 1992. And interestingly, it was the first time when human rights organizations from Northeast have also gone and submitted their alternative reports to the government of India's report. In 1983, not many people were aware of these procedures, but it was our Naga friends, the Naga People's Movement for Human Rights, went to the United Nations in 1992 and submitted a report, particularly on the exercise of this law called the Armed Forces Special Powers Act. And we all know how Armed Forces Special Powers Act has been instrumental in violating many basic human rights. And the Human Rights Committee look at the report that was submitted by the Naga People's Movement for Human Rights, look at the report that was submitted by the government of India, and they engage the government of India into a dialogue. And in the concluding observation, the Human Rights Committee came to the conclusion and recommendation that Armed Forces Special Powers Act violates a series of human rights which are enshrined in the International Covenant on Civil and Political Rights. Right to life, which was Article 6 of ICCPR, or the International Covenant on Civil and Political Rights. Article 7, which is right against torture. Article 9, right against arbitrary detention. Article 14, right to fair trial. So all these rights which are supposed to be guaranteed to all the citizens of India once you sign the International Covenant on Civil and Political Rights, these are in fact being suspended when you exercise Armed Forces Special Powers Act, where military can just pick up anybody without warrant, interrogate them, and use force to the extent of causing death. So that is how right to life, which cannot be taken away by anybody, because it's a basic and fundamental human right, are being violated. And the committee also said that, see, when a country is facing a very serious problem, like something that threatens the life of the nation, then you can declare a state of emergency and derogate from some of these human rights obligations. But there are certain rights which can never be derogated, even if it is a state of emergency, or even if you are going out for a war with another country. And these are what they call non-derogable human rights. And the committee have also observed that many of these rights which are being suspended by the Armed Forces Special Powers Act are in fact these non-derogable human rights. Right to life, right against torture, right to fair trial. These are non-derogable human rights which cannot be derogated from by anybody, even if they are facing a state of emergency, or for that matter, even if they are going out for a war. You can't just kill people arbitrarily. It's one thing that the military shoot at each other and kill each other. That's a different thing. But you cannot just pick up someone, a civilian, take him to your camp, torture them and kill them. That is not what human rights agrees upon, and that is what we call non-derogable human rights. Anyway, interestingly, in the third reporting of India was in 1997, and that was a time when I personally was able to go. I have just finished my law and was doing human rights work, and we were able to be in Geneva when this discussion was happening on India's civil and political rights issues. And Manav Adhikar Sangram Samiti at that time in Assam was also very active. So there was also a representative from Manav Adhikar Sangram Samiti, and we engaged with the Human Rights Committee, and Human Rights Committee again came out with a series of very sharp recommendations. One of the very key recommendations that came about was what I still remember, concluding observation number 19, which basically said that, see, in these areas where the Armed Forces Special Powers Act has been there for a long period of time, as they have already pointed out, it violates right to life, right against torture, right against arbitrary detention, right against fair trial, right to fair trial, etc., etc. And therefore, the human rights situation in these so-called disturbed areas needs to be very closely monitored. They have also requested the Supreme Court of India to discuss whether not only because at that time the representative of Government of India told the Human Rights Committee that this matter is pending in the Supreme Court. The Supreme Court is hearing the constitutionality of Armed Forces Special Powers Act, and therefore they would like to keep this and discuss this in the Supreme Court. The Human Rights Committee very clearly pointed out that when the Supreme Court examines the Armed Forces Special Powers Act's constitutionality, they should also examine the covenant compatibility of this Armed Forces Special Powers Act, meaning that whether the Supreme Court should not only examine whether it violates the fundamental rights given in the Constitution of India, but it should also ensure that India's obligation under International Covenant on Civil and Political Rights should not be violated. Unfortunately, though, the Supreme Court ignored that recommendation and they didn't go through in its judgment, which came out on the 27th of November, called the Naga People's Movement for Human Rights versus Union of India. They completely ignored that request from the Human Rights Committee. And perhaps because of that and for other reasons, India have not reported back for the fourth time in the Human Rights Committee. They were supposed to report it by 2001, but only now we are told that there was a delay of more than 20 years, and only now we are told that the Ministry of External Affairs have started the process of drafting the human rights, the fourth report that needs to go to the Human Rights Committee. So this is a quick bird's eye view on how issues of human rights in the Northeast was kind of integrated into the Human Rights Committee discussion. But as I was telling you, this is only every 5 years. And if the government doesn't report, then there's no debate. So this frustration of many people complaining that UN is basically useless because it's not able to address the situation here and now was a very common criticism. In the late 70s, 1970s, there was a very creative person, a professor called Theo Boven from Netherlands. He was the director of the Human Rights Unit of the United Nations. And he came out with a very novel idea. Because rather than the UN discussing issues of human rights, he formulated an idea of independent experts being appointed by the Human Rights Commission. At that point of time, it was called the Human Rights Commission, and asked to study a particular phenomena of human rights. And he will collect information from all over the world, including many of these complaints that people want to complain. And he will write an expert report and submit this report to the Human Rights Commission so that it can be discussed by the Human Rights Commission. So it was not directly accepting petition from victims or oppressed people, but an expert receives these complaints or expression of concern and prepare it into a proper report and submit it to the Human Rights Commission, place it in a very tight, succinct summary report, and then this can be discussed. So this practice was there to address some very key human rights concerns, which has become a big international issue. But interestingly, in Latin America in the late 70s, there was also the time where the communist movement, socialist movement was coming up in a big way. And with the help of the military and with the support of United States, there was very brutal repression. At that time, the mothers of Argentina, where thousands of young people disappeared because they were involved in the so-called insurgency operations, just disappeared. They were picked up from the house and they never came out from the military barracks, and the family do not know where they are. So the mothers of this, victims of disappearances came together and formed an organization called the Plaza de Mayo. They just wear black, and every Thursday they go and stand in front of the Plaza de Mayo, a huge kind of a ground in front of the presidential palace in Argentina. And these movements become very, very powerful. And so with the help of human rights organization, they went to Geneva and started protesting there. And interestingly, for the first time, the United Nations constituted what is called a working group on enforced and involuntary disappearances, where they accept the plea from the families where their sons and or husbands or daughters have disappeared from their family. So they received this complaint, and this working group, which is constituted of about 5 people, they examine this complaint, and if they think that it is a genuine complaint, they ask the respective government, here it's Argentina, to respond within a certain period of time. What happened to this person? They are not saying it is right or wrong to arrest him or not arrest him, but it is the duty of the government to at least identify where they are and what is the charges which are put against them. So, and of course, this was not confined, this mandate was not confined to only Argentina. This was a worldwide mandate, and this became the first, what we call thematic procedure on disappearances. People, there was a procedure that was established that any person, particularly the family members, can complain to the United Nations that my son, my brother, my daughter, my son has disappeared. Please help us find this. And the United Nations Working Group on Disappearances will take this up with the government, and they will continue and insist the government to find out, at least disclose where the whereabouts of this person. And this will continue, the correspondent will continue at least 10 years if they are not able to produce it. And every year when the Human Rights Commission meets, they will come out with a report of the number of complaints country, the number of responses that they have got from this country, and whether they were able to finally track the person or not. So this has become a huge embarrassment for many of these Latin American countries which were indulging in this kind of practices. And slowly they started solving the problem, quote unquote, the military way, and therefore they started just killing these people. So once you kill the people and find them in their dead bodies, then the file is closed in the United Nations. So this become a very easy way out for the governments to deal with this problem. So the UN was also in a dilemma, the Human Rights Commission, whether they should pursue this mechanism or they should just retreat. But one country stood out and said, it was Sweden, which said, no, we should not retreat, but the same procedure should be applied when it comes to killing of people suspected to be executed by the state without a proper judicial announcement. So the same way as they started this working group on enforced disappearances, Sweden sponsored whatever cost that is required for that. They will pick up the bill, and they constituted what is called a special rapporteur on extrajudicial execution. So this became a trend. So later there was an extrajudicial special rapporteur on torture, special rapporteur on violence against women, special rapporteur on sale of children and child pornography. So for every thematic human rights issue, special rapporteurs are being appointed. They are being serviced by the Office of the High Commissioner for Human Rights, but they are independent experts. They are not the UN, but they are given the mandate by the UN to study this phenomena. And this become a very effective tool where people can start questioning, raising their issue. And they even come and visit these countries. So the special rapporteur, India have extended, and I mean, today we have something like 44 special procedures in the United Nations looking into specific issues of the of human rights. They are called the thematic special rapporteurs or the thematic special procedures. And they also do field visits. They go to the country and they visit the country and write a report on the situation of that report. So India have also extended an open invitation to all the special rapporteurs to visit India. And because of this open invitation, many special rapporteurs have visited India, and they have also visited Northeast. The first one to have come after India have put this open invitation was Margaret Sakagia. She is the special rapporteur of human rights defenders. We know that human rights is something that the world have accepted, but we also realize that many of these people who are trying to actually protect human rights people or very vulnerable people are being attacked by powerful forces in the society and sometimes by the state themselves, because they are seen more as a troublemaker. And so there is a special rapporteur on human rights defender. Margaret Sakagia was the human rights defender's special rapporteur in 2011, and she visited India and she visited Guwahati also, among many places that she visited in 2011. Next year itself, in 2012, special rapporteur on extrajudicial execution, killing people without a judicial pronouncement. Remember Sweden, remember the disappearances and how the struggle happened. At that time, the special rapporteur was someone called Professor Christoph Heinz. He's a professor of law in South Africa, and he was given the mandate by the United Nations to look into the phenomena of extrajudicial executions. And he wrote a very sharp report criticizing the Armed Forces Special Powers Act, which gives the power to kill, a sanction to kill to the security forces. And he also very clearly stated that this power that is granted to the military under the Armed Forces Special Powers Act transgressed what is acceptable, even if there was a declaration of state of emergency. But in this context, there was no state of emergency, and yet there is many of these rights which are supposed to be protected, even in the state of emergency, are being suspended. And he also wondered how the Supreme Court of India, which is otherwise so progressive in other human rights jurisprudence, could possibly uphold a law like the Armed Forces Special Powers Act. We from Manipur have also submitted a memorandum to Professor Christoph Heinz listing 1,528 cases of extrajudicial execution under the Armed Forces Special Powers Act, under the SEDO of Armed Forces Special Powers Act, which was later converted into a public interest litigation in the Supreme Court. And after a lot of debate, the Supreme Court have come out with a judgment in 2016, where they said, even if there is Armed Forces Special Powers Act, when a citizen is murdered, then the criminal investigation should take place and people who are responsible should be punished. So under this, CBI has done an investigation on 39 cases out of this 1,528 cases. And by now we have something like 100 policemen in Manipur who are being indicted for murder charges. Unfortunately though, not a single military personnel who was clearly established by the CBI as involving in this murder have been indicted, because Armed Forces Special Powers Act requires that there should be prosecution sanction from the central government, and central government has not given prosecution sanction to any of the armed forces personnel involved, despite CBI asking for that officially. That is the situation in which we are present. Then after that, the UN Special Rapporteur on violence against women, Rasida Manju, came in 2013. So on and on, many special rapporteurs have started coming to India and have also come to the Northeast and have started looking at some of these issues. And many of these issues are now written about, commented, and recommendations have been given to the government of India on these issues. I know I'm running out of time. So let me wrap up here. Just one more point, perhaps, which will be important, is that in 2006, United Nations did a review of the, what they call rationalization of the United Nations anyway, they reviewed the way in which the United Nations human rights procedure was functioning, and they tried to improve it and rationalize it. And in 2006, instead of Human Rights Commission, they have upgraded the issue of human rights to a Human Rights Council. The difference is that in Human Rights Commission, anything that deals with budgetary issues cannot be decided in the Human Rights Commission. It has to be put up to the ECOSOC, Economic and Social Council, then can they take a decision. Whereas Human Rights Council is higher in terms of the hierarchy of structure and body. And so Human Rights Council can also take positions when it involves budgetary issues, and it's much more higher in terms of the United Nations hierarchy, and it's now in the same status as the Economic and Social Council. And there, in the Human Rights Council, they have started a new procedure called the what you call the Universal Periodic Review, where they said all the countries of the world will be examined about its performance in human rights, irrespective whether they are big or small, rich or poor, good country or bad country.
Please mute yourself. Please mute yourself.
Yeah. And this examination will be done not by the experts, by the governments themselves. So out of the 193 countries in the world, one country will be examined by the remaining 192 countries, and they will give recommendations on what needs to be done in this country. So it's a tedious process. It is done in 3.5 hours. So imagine 3.5 hours is about a long Hindi film movie. So all the human rights issues of India has to be examined within this country, 3.5 hours, and all the countries can ask questions. So it's a very elaborate process. It has to be done very systematically. But what is interesting is here also, stakeholders like civil society can also submit our own report to the United Nations. And if you are an individual organization, it has to be a 5-page report. If you are a collection of different organizations, it can be up to 10-page report. Again, how big your font is and all are being examined, but let me not go into those details. But what is interesting is that now the United Nations also recognize that for human rights mechanism to be real and alive, it is very important to involve the victims, the civil society, and the people who are out there, and not just the government. So now this process of the Universal Declaration on Human Rights is very important. India has been examined first in 2008, second in 2012, I guess, and the third had already happened in 2018, and now the 4th cycle has begun. So if there are people who are interested, we are also preparing the civil society report by a group called the Working Group on Human Rights in India and the UN, and I have been helping in putting issues from the Northeast and chapters in the Northeast, and we usually do consultations. So if any of you are interested, you are also more than welcome to participate in these processes to raise issues of concern, and we will be very happy to incorporate it when we present this to the Universal Periodic Review process. But it's again, millions of issues is going to come up. Whether our issues will actually be come up or not depends on whether the government who are examining that country is interested in that issue or not. In the last Universal Periodic Review, for example, Switzerland and United States and Pakistan raised the issue of Armed Forces Special Powers Act, for example. I mean, there are something like 169 recommendations that came to Government of India, and out of that, some are accepted and some of them are being implemented by the government. Some of them are ignored. Let me stop here, but I'll be happy to answer questions if there is any from the students, researchers. Thank you.
Thank you, sir. It was very pleasant listening to you, your step-by-step description of each and every issues. So our audience have definitely gained from your description, sir. So now, participants, if you have any query, any observation, or any question, you may proceed with your observations. If anybody would like to ask anything. Anybody have any question or any view?
Or criticism?
Yes, criticism. So Perhaps, sir, your lecture was so, simple and pleasant and in-depth that everybody have got their points, I think so. So, but I would like to inquire something that is that Armed Forces Special Act that has been being imposed in northeastern states. What do nation get from it? What the profit of the nation by imposing such laws?
Good question. This could be better answered by the government themselves. But my understanding is that, in 2004, when the Thangzam Manorama incident happened and when these mothers went to this protest in front of the Kangla fort, the Prime Minister at that time have promised the people of Manipur that this will be replaced by a more humane act. Dr. Manmohan Singh have clearly stated this, and he have constituted a committee headed by Justice Jeevan Reddy to look into it. The committee, even though they did not officially release the report, this was leaked in Hindu newspaper, and it was clearly stated that they have also recommended that this law has become too present and it was not so useful, and at the same time it has become a symbol of oppression, an instrument of discrimination, and it should be repealed. That was which has come out from a rational process within the government. But we were told that there were very strong objections to this report's finding, which was also concurred by the Administrative Reform Commission, and also by various by Justice Burma Committee, which was set up to look into sexual harassment. But even though the judges and the bureaucrats and diplomats say this, apparently the military is very strongly against it. That's what we have been told. The matter was placed in the Cabinet Subcommittee on Security for a very long time, and we were told people like Sonia Gandhi and even Chidambaram were all in favor of amending, at least to some extent. But the Defense Ministry, we were told again, we don't know, were stubbornly against it, because they see, I think, more as a morale of the military, that if they start facing all these charges of if the military have to go to the court constantly, then their morale will be broken. So the question is whether the morale of the soldier who are indulging in dirty human rights violation should be protected, or the citizens' rights to human being and human rights should be protected. So that's a call for the government to take. And if from the point of view of human rights movement, the United Nations expert bodies are very, very clear. Even the UN's not only expert, but the UN High Commissioner for Human Rights, Madam Navin Pillay, when she came to India in 2008, in a speech that was delivered in Ashoka Hotel on the invitation of the National Human Rights Commission, she was also very clearly saying that this is a dated law of a wartime era, and it will be best in India's interests to, as a country with a modern democratic thrust, to get rid of this kind of dated laws. So from the point of view of human rights, it is very clear. It is doing more harm than good. But I still don't understand the military logic very well, particularly when in Northeast, it is quite clear that insurgency has come down to at least 80%. That's what our Honorable Union Home Minister have said. There's hardly any serious threat to national security, and yet they are extremely reluctant to get rid of this law. So sometimes many people think that, in fact, we have also used the UN Committee on Racial Discrimination, the way in which this law was used only to a certain community, even though there is a much stronger insurgency in Chota Nagpur and the Red Belt. Armed Forces Special Powers Act was not used, whereas in the Northeast, it has been used from 1958 onwards. So the UN Human Rights Committee, after looking at it and also looking at how Jeevan Reddy Committee have already said that this has become an instrument of discrimination, they have stamped Armed Forces Special Powers Act as a racist law. And if there is a racist law, the same way as South Africa was criticized by Vidya Lakshmi Pandit in 1946, India was also criticized, and the Racial Discrimination Committee have asked India to repeal this law within 1 year. This was 2007, February 2007 to be precise. Yet there is no response from the government till date. So we feel very strongly about it. I mean, we should ask, we should perhaps invite a military general to explain how does it help, particularly when it is not so useful for the citizens themselves and for India's own image in the international community and in the human rights world.
Hello.
Sir, am I audible?
Yes.
Dipen, am I audible?
Yes, you are audible.
So my screen is giving some problem. Am I audible, Dipen?
Yes, you are audible. Manoj.
Hello. Can I ask a question here?
Yeah.
I'm not getting the sound. Dipen, am I audible?
Yes, audible. You are audible, Manoj.
Hello. Can I ask a question here?
Yeah, sure. You can.
If I'm not mistaken, the Armed Forces Special Powers Act is extended based on the report of disturbed area. So I would like to know whether the criteria for declaring a state as a disturbed area, whether it is based on the recommendation of the state government or by the center itself. Thank you.
What is disturbed area is an issue which was discussed also in the Supreme Court when the Armed Forces Special Powers Act's constitutionality was being deliberated by the Supreme Court Constitution Bench in 1997. And there, many of the petitioners, people who are wanting APSPA to go, also wanted that there should be clear criteria that the Supreme Court should lay down what will be defined as disturbed area. Number of bomb blasts, number of attack on security, extortion demands, etc., whatsoever it may be. But after listening to all of that, the Supreme Court have come out with a very interesting formulation saying that the administration knows what is disturbed, full stop, nothing more than that. And there was also a plea that the disturbed area status should be, there should be a possibility to challenge this judicially. I mean, if you think that your district has no such record and still the administration have declared you as a disturbed area, then there should be an opportunity to go to the court and challenge this. Unfortunately, that was not what the Supreme Court think. And in terms of who can declare disturbed area, up to 1972, it was only the state government which was given this authority to declare an area as a disturbed area. But however, in 1972, there was an amendment, and they said it is now both the state as well as the central government who can declare an area to be disturbed area. There were many instances, particularly in Nagaland, where the state cabinet have decided that disturbed area is no longer required because they are in a ceasefire agreement since 1997, and not a single attack has happened against the security forces. However, despite of that decision by the state cabinet, the central government have declared disturbed area in Nagaland several times. There was also an instance in 1972, when Tripura doesn't want to come under Armed Forces Special Powers Act, because in 1958, it was only Assam and Manipur, and at that Assam covered almost all the region except Tripura and Manipur. So, but in 1972, Tripura was also brought in. That was also very strongly objected by the state government, but nevertheless, the central government decision rules there. So at this point in time, it is both the state and center, but the word of the center overrides the decision of the state government, as it's clearly seen in Nagaland today. Does that answer the question, Peter?
Yes, sir. Thank you so much.
Thank you, sir. On behalf of the organizing committee, I, from the core of my bottom, from core of my heart, I thank you. Thank you again for your valuable time and valuable speech. You have given us a lot. We have really enriched by your lecture, and hope we will meet again soon and gain by your valuable lectures. So thank you for coming and giving your precious time to us. This is the end of the technical session, and in next session, the coordinator will take the attendance of participants. So I request all the participants to be there for feedback and attendance at the last technical sessions. Thank you. Thank you, sir, again.
Thank you, Manojji. And thank you, Dipan.
Thank you, sir. Thank you very much, sir. Thank you, Dr. Manoj. Now we are going to record our attendance of the participant. So as we have already uploaded the guideline for the participant in the WhatsApp group, now we are going to record your attendance in today's program. So your serial number will be recorded as your roll number. So please give your presence. Roll number 1, Niyaz Ahmed Ansari. Roll number 2, Dr. Pranjit Soikia. Again, I am repeating. Roll number 1, Dr. Niyaz Ahmed Ansari. Roll number 2, Dr. Pranjit Soikia. Roll number 3, Dr. Ritumani Haloi.
Yes, sir.
Yes,
Sir.
roll number 2, I am here.
Okay. Roll number 2 is present. Roll number 3, Dr. Ritumani Haloi.
Yes, sir. I am present here. I am hearing.
Roll number 4, Meghali Bhattacharya. Roll number 4, Meghali Bhattacharya.
Yes, sir. Yes,
Roll number 5.
yes, sir.
Roll number 6, Jintimani Samua.
Yes, sir. I am present here.
Video during the entire technical session, you have to switch on your video. Roll number 7. Roll number 7.
Yes, sir. Present, sir. Roll number 7.
Roll number 8. Arundhati Lahan, Dr. Arundhati Lahan. Roll number 9, Dr. Ramesh Prasad Paul. Roll number 9 absent. Roll number 8 also absent. Roll number 10, Mary Halam.
Present, sir. I am present, sir.
Okay. Roll number 11, Miss Rupjyoti Das.
Yes, sir. I am
Roll number
present.
12, Anand Chandra Ghosh.
Present, sir. I am present, sir.
Thank you. Roll number 13, Dr. Soindhak Sua. Roll number 13 absent. Roll number 14, Jatin Chandra Burwa.
Sir. Yes, sir. Roll number 6. Yes, sir. Roll number 15 present.
Pallavi Saikia.
Yes, sir. Present. Present, sir.
What about roll number 14, Jatin Chandra Burwa?
Present, sir. Present, sir.
Okay. Okay.
Yes.
Roll number 16, Dr. Aravind Shah Barkade. Roll number 16 absent. Raza Dole. Roll number 17 absent. Roll number 18, Mrs. Runu Gogoi.
Yes, sir. Yes, sir.
Roll number 20, Dr. Jamal Rahman. Roll number 21, Imina Lama.
Present, sir. Present, sir.
Dr. Vinali Das.
Present.
23.
Yes, present.
Thank you. 24, Tapati Doctor. Roll number 24.
Yes, present.
25, Dr. Zonti Burwa.
Present.
Yes, sir. Present. I am present. Zunti
Biswajit
Bora
Bora.
present.
Okay. 26, Biswajit Bora. Absent. 27, Sima Nath. 27, Sima Nath absent. 28 Sangita Pukon.
Yes, present.
29 Dr. Nivedita Sajja.
Yes, present, sir.
30 Bonali Sutia.
Present, sir.
31 Lohit Chandra Boisya.
Sir, 31 Lohit Chandra Boisya, present, sir.
32 Pranjal Hazarika. 32 absent. 32 absent. 33 Dr. Pradeep Burman.
Yes, I am present here.
34 Dr. Krishna Rai Sohan. 34 absent. 35 Upama Gurung. Absent. 36 Rahul Bania. Absent. 37 Peter Ki.
Present, sir.
Okay. 38 Mr. Ditul Lahon.
Yes, sir. Present.
39 Harihar Deka.
Present, sir.
40 Arsana Nath.
Present, sir.
41 Dr. Deepjyoti Bhuya. 41 absent. 42 Dr. Mainu Goswami. 43 Dr. Midusmita Devi. 42 absent. 43 absent. 44 Rumi Soikia. 44 absent. 45 Dr. Sandana Das.
Dr. Sir, present, sir.
Okay, thank you. 46 Agustin Terang. 46 Agustin Terang. Absent. 27 Mandira Bora. Absent. 48 Dr. Kakoli Bora.
Rumi Soikia, present, sir.
Dr. Kakoli Bora. Present. Dr. Kakoli Bora. 48 absent.
Sir.
49 Tulika Sangmai.
Hello.
Sir, present, sir.
What's your roll
Hello.
number? Roll number?
49.
49. Okay,
Hi.
Tulika Sangmai present.
Yes.
Rosalina Siraj Farjina Akhtar. Roll number 50. Absent. 1 Dr. Vijay Krishna Nath. Vijay Krishna Nath. 51 absent. 52 Dr. Shivani Phukon.
Yes, I am present.
Okay. 53 Gunaviram Gugoi. Absent. 54 Mayuri Sharma.
Yes, present. Mayuri Sharma, present.
55 Ukheswar Bora.
Yes, present.
5
Yes, present.
57
Premkanda Bora is present.
58 Dr. Tolikko Gogoi. Tolikko Gogoi absent. 59 Konseng Barua.
Present, sir.
60 Miss Rita Das. Rita Das. Absent. 61 Pranita Kolita.
Present, sir. 61. Pranita Kolita.
2 Nirupam Phukon. Absent. 63 Dr. Hima Hazarika Das.
Present, sir.
64 Monojit Purakaistha. 64 absent. 65 Dr. Manos Das.
Yes, present.
66 Zinirani Boro.
Yes, I am present.
67 Bhaskar Kakoti. 67 absent. 68 Parag Kumar Deka.
64, I am present.
68 present.
Sir?
69 Edith Panikar.
64, sir.
Edith Panikar 69.
Yes, I'm here.
70 Mr. Plavon Bhia.
Present, sir. I'm
Sir, are you hearing me?
What's the roll number? Tell me.
64, sir. 64.
Okay.
70 present, sir.
Sir, roll number
64,
34.
Monojit Purkaistha.
Let me complete-
Hello.
let me complete first.
Hello.
Let me- Roll number 70,
Hello.
Mr. Plavan Bhuya.
Present, sir.
Hello,
71,
I am
Susila
Dr.
Murali.
Roshni Doctor.
Yes, I am present, sir. 71.
Okay, 72, Prakash to
Hello.
72, 72,
Hello.
72 absent, 73, Dr. Osini Mase. Let me
Hello.
complete first, then you can speak. Dr. Osini Mase. Dr. Osini Mase, absent. 74, Navanita Soikia.
Yes, sir.
Navanita Soikia. Okay, 75,
Yes, sir.
Saiki Talukdar. 75, Saiki Talukdar. 76, Satung Luang. Absent. 77, Pamsila Bhutia.
Present, sir.
78, Bhaskar Khanikar. Bhaskar Khanikar. 78, absent. 79, Anupama Tamang.
Yes, sir.
Roll number 80,
Yes,
Binjoy
sir.
Nirin.
Present, sir.
81, Sansan Wahem.
Present, sir.
Roll number 81.
Roll number 81, present, sir. Hello.
82, Sandila. Kumar Jaswant. I think 83 is absent. Okay. So is there anybody left out?
Hello.
Rumi Khaikia, 44.
44
Hello, my
present.
roll number. Yes, my roll number is 50.
Okay, 50 present.
Sir, my number is 64.
70 is present. Sir, my number is 41. Dr. Dipjyoti Rina.
Sir, my number is 34. Dr. Krishna Rai Chahal.
So
Hello.
my number is 50. Dr. Roslyn Sras Fatina Akhtar.
50 present. Okay.
Hello.
Sir, my number is 64, sir.
Hello. Sir, my roll
64,
number
okay,
is
64.
64. Hello. Sir, my roll number is
64, sir.
64 present. Present.
Roll number 44.
64 present, sir.
Sir, roll number
Yeah,
41.
44 present,
Sir, roll number
41 present.
70 present, sir.
So better you can tell the absent numbers.
Oh, yes, sir. Yes.
Okay, okay, okay.
Better you can tell the
Roll
absent numbers, sir.
Roll
Okay,
number
okay.
60
Number 44.
present. Dindumani
Roll number
Cinema.
Dr. Dipender sir,
Yes.
Yes, sir. Roll number 44.
here is an announcement. Already attendance link that was shared in the chat box. Please check it. You can fill up your attendance form. Which was
From where,
shared in the
sir?
chat box.
No, it is there in the chat box. You can go through this.
Checkbox.
Yes.
Where, sir? Checkbox is.
Yes, sir. Yes, sir. Koi থাকিব লাগে। শুনাও।
Sir, can you please repeat the absentee name?
Okay, roll number 44. 44?
Sir, roll number
Present?
44. Yes, sir. Yes, sir.
Yes, okay. Roll number 51. 51. Roll number 16. 17. Roll number 20. 53. 58.
Roll number 60, present, sir.
Not 60, it's 60.
Roll number
16.
60.
It's 16, not 60. It's 16, not 60. Roll number 22. 22 absent. 26. 27. Roll number 83. 75. 76, 62, and 60 present. 32, 34.
Present. Roll number 34 present, sir. Dr. Krishna.
34 present. Okay. Roll number 82.
Present, sir.
67.
82 present.
82 present. 72. 73. 46. 47. 48. 42. 43.
57 is present. 57 is present. Dr. Premkanta Bora.
57 it is already there. Okay, 35, 36, 32. Okay, let me announce one more thing. So regarding your presentation, so you have to present a paper on any issue related to the main theme, that is human rights education. Then 5 minutes will be for your presentation, 3 minutes for presentation, and 2 minutes for interaction. We divide the entire participants into 3 sessions. I will give you details in the WhatsApp group. So with this, today's session is over. Now we have assessment session, and our technical coordinator will communicate with you.
Thank you, Dr. Dipender sir. The link for the assessment will be available in your chat box. Please check your chat box.
Not